Good morning, everybody. We are at NFT MSP 2024, Saturday, August 31st, our second day of the event. Last night, we went from 5 to 10 p.m. in our opener with Minnesota Blockchain Society and some others on a panel. This morning, we're actually with Merchant and Gould. We have Peter Tram, Andy Legata. Ben Tram, Andy Legata, and Will Schultz right here for Merchant and Gould. We also have our artist of residence and organizer of the event, Sean McCann here from Canvas Convergence here at the West End. The topic this morning is going to be on IP, copyright, and AI with the emerging technology in digital assets, blockchain, and artwork. So without further ado, I'm going to actually let Will here introduce the rest of his crew and everybody give their own bios. So thank you, everybody, for coming. This is being live streamed. For those who don't know, you can actually tip the panel via live stream if you go to our website, which we're getting the link embedded here in a moment. And those artists and participants from around the world can actually be tipped by those audiences. So thanks, guys. Here you go, Will.
Awesome. Thank you, Chris. I just want to say we're gonna answer questions if you've got questions too. So we've got a little bit of a presentation here, some topics that we're going to go through. But if you've got questions in this area, it's emerging, and we're going to have a good interactive time here this morning. My name is Will Schultz. I'm a partner at Merchant and Gould. I specialize in brand protection. What does that mean? I help brands who have trademarks protect those from people who want to steal them. I also work in emerging technologies. So when new technologies come out, like blockchain and NFTs and AI, I stay on top of that. I work with leaders around the industry as well as the legal community and try to stay on top of the legal trends as well as the business opportunities that my clients have in those areas, and then counsel those clients on how to interact with the emerging trends that are happening.
My name is Ben Tram. I'm a partner at Merchant and Gould, and I help companies protect their inventions and technology. I have a background in electronics and software, and so I tend to focus on those areas, and I'm the chair of the department in our firm that handles electronic and software patent protection.
I'm Andy Legata. I'm also a partner at Merchant and Gould, background in electronics and software as well as similar to Ben. Have been working in the sort of AI space for 10 plus years.
Wait. Say that again. 10 plus years.
Yeah.
Okay, so it's not when ChatGPT came out in 2023. He's been working in this area for 10 plus years. Let's just make that clear.
Do a lot of sort of enterprise level IP portfolio development associated with AI technologies.
Hey, Sean?
Wonderful. My name is Sean McCann. I am a street artist, muralist, gallery owner. I've got Canvas Convergence, which is across the street. I run and organize 11 different street art, chalk art festivals around the country. And so for me, it's all about how can I be a creative and how can I keep producing amazing pieces of art and what that means in today's ever-changing society. So it's one of those things that I love being able to really bring new and exciting things to events and to spaces and to all of that. So thankful for all of you being here today and to talk about this very important topic and something that is such a confusing thing for so many, especially with the advancement of technology and AI and all of these different things that come from just the different aspects of creation and use of that and moving forward with that. So, but you said you have a presentation. Are you wanting to do that first, or would you like to get into things before that?
Well, we'll mix it all up. I'm going to start with a question for you, actually, Sean. You've got a brick and mortar gallery right across the street.
Yes.
How do you use that brick and mortar store and then interact with the emerging technology such as AI in the art industry for yourself?
Well, it's something that this is my first brick and mortar that I've had. It's been something that a lot of the things that I've done leading up to this for the last 20 years has been a temporary, ephemeral quality-based stuff, so it'll be event-based, and you create it, and then you're gone, and then it disappears, and it only exists in photographs. Having a more physical space, it's something that we have lots of people that are, constantly coming in, taking photos of the art, utilizing the art for, their social media, different things like that. We've had people that have, made their own art based upon what they've seen in that. And as an artist and creator, utilizing AI to a certain extent, it's not something that I'm just generating something and then all of a sudden throw that out there and that's what it is. But I found it to be just another tool that is available in the creation of what we do, to where it's something that if I need a specific pose or a specific look or feel that I'm just not trying, not getting, AI has been sometimes beneficial in that sense. It all depends on if you hit those right keywords and things, because even you can even put the same phrase in twice and it doesn't come out with the same results. So it's still in its infancy of where it's going. It's rapidly developing. I mean, what it was 6 months ago versus what it is today is insane, and it's going to be wild to see what comes in the next 6 months or even the next 2 weeks, or and everything. So for a creator, it's another aspect to building your all the different tools that you can utilize for that. So, but then there are other sides of it with copywriting. If your art is being utilized to put into the search engine and create content that is exactly like yours or stuff. And so there's a dual side to it from the creator standpoint, and then also from the copyright standpoint of like if your stuff is being, whether it's stolen or utilized to enhance something or whatnot. So I think for a lot of artists and creators, it's just something that we're trying to find that balance of where is that line? Where is it a point of somebody stealing your artwork, or how is it that these companies can search all of the work and your history of what you've done as an artist, and does that cross that line? And so it's been an interesting last 6 months, year. It's gone so fast. I don't even know when it like officially started coming into play, because it just seems like a week ago is like a year, but it's not.
So I want to dig into a lot of what you talked about in terms of the art and the creation behind that. Andy, I know you've got a comment here, but could you also touch on the technology behind the AI? How is an AI model developed that would include Sean's art?
Well, so there's a lot of different types of models. Most of the models you're talking about are the diffusion models, the type that are generating images based on prompts, right? So they are very hard to control from an ability to generate reliable output. One of the comments that we were talking about prior to this was the extent to which a model like that is able to be controlled by an artist like yourself in a way that you're able to provide sufficient specificity as the input to get some output from the model that is at or close to what you want, and the extent to which that input provides enough of the sort of creative insertion that will allow you to retain rights. So I think we'll want to, I'm actually going to kick this back to Will here in a second to talk a little bit about the extent to which, for example, copyright rights attach when you're starting to use those AI systems, those diffusion models, those kinds of things, because in some instances when it really is not sufficiently directed, there may not be a whole lot of rights available, but where we think there's more direction, more user input into it, there's more of a case for protection. It sounds to me like what you're using it for is very early stage, and it doesn't actually reflect significantly in the output of your art. I would assume that to be the case, but I would assume some more basic versions where you're like, generate an image, and that image is what it's going to be. That's where I'd want to hear where those two cases may come out differently from an ability to protect, ability to keep others from doing something similar.
Yeah, I mean, it's one of those things that you're starting to see, like, even on social media, where you can tell that it was generated by AI, but they're not representing it as that. And in some cases, they're starting to have it to where they're required to say this was an AI generated image. And so as creators, there are definitely creators out there who are utilizing AI and for the most part don't change a whole lot once it's generated. And so it's something that, as that ability to specify to the nth degree and really, hone in on your image and create that, and what if you throw in, a client's image that you're utilizing into a system, with centralized versus decentralized? Is it something that, because there are some cases where, searches can be censored to where you can't search for that and stuff, versus if you have your own ability to, do that kind of stuff or generate an image or whatnot, and then you're throwing somebody else's, image in there. If you're working with them on a project, then it becomes like, convoluted. Like, where does that lie? Because like now all of a sudden you've thrown their stuff into that generator, and so it's really fascinating.
So just really briefly, I'm going to push this back to Will here in a second to talk a little bit about the rights piece. On the technology itself, I don't necessarily want to focus on the diffusion model concept because those are relatively complex. But if you think about it just in the context of, for folks who aren't using a lot of AI tools, for example, a large language model or those kinds of tools that everyone's sort of seen, the OpenAI versions, Gemini or whatever Google's is called these days, essentially predicting from past text the likelihood that two words are going to appear near each other in a sort of lexicon sensible way and generating something that appears to be an answer that makes sense. It may not in fact make sense. It may not in fact be something that's factually accurate, but it's truly just based on, sort of language probabilities and structures that are seen in past text in that case, or past images in the case of diffusion models. So it's really just a predictor, and it's interesting to see that with the level of I would call it just sort of probabilistic change, even when the same input is provided, that's what sort of drives some of these outputs, right? You're going to get different outputs every time you try, basically, just because of the extent to which those models are generating, have built in the ability to be a little bit more probabilistic and less deterministic.
Yeah, because I mean, you're starting to see a lot of this kind of stuff with music and video, and it's not just imagery and stuff like that. It's going to affect basically every level of creativity and production, and so it's just one of those things that as we move forward, where is that line where it's like, do you still own it? Do you not own it? Can you utilize it for business use? Because we were even talking about, like, if you have an asset that's like stolen that you're using as a business, and all of a sudden somebody else buys it and wants to use it, like all the different things. And so with the blockchain technology and all the different elements that can go into usage of images, and who originally generated it, who owns the the copyright or the patent or the trademark on the overall, and then what kind of licensing you have for things. There's just so much to unwrap as we move forward with production of artwork and creativity, and just so many different facets of that. So
Yep. So we've got a lot to break down, and I'm going to start off by just talking real quick about ownership rights and copyright rights. Starting off with the copyright aspect of this. This is one of the first. This is Zarya of the Dawn, and it is a kind of a comic book graphic novel that was submitted for copyright registration to the United States Copyright Office. And originally, it was granted a copyright registration. The author then made a bunch of posts about the work, saying that it was created by AI. Copyright Office sent a letter back out saying, we need to know more information about what you're talking about here on created by AI. Ultimately, the Copyright Office rejected or revoked the copyright registration associated with the graphic novel because it was generated by AI. And there was some fights back and forth. The Copyright Office eventually gave a revised registration that included the human-only elements that the author had created and did not include the AI-generated elements. Since that time, there have been some further developments in the area, and essentially it is that if you are doing arranging and you apply for the arrangement of artwork that is created by AI, you can get copyright rights in that. Why is that important? Well, in the United States, in order to bring a copyright lawsuit, you have to have a copyright registration. In other words, companies that are going out there or artists that are going out there and using straight up AI and then using that as their artwork, infringers can essentially take that if there's no copyright registration, because there's not the enforcement mechanism in order to stop that person from doing that. So by having some rights associated with at least the arrangement, there's some teeth behind where we're at.
Can I ask a question?
Yeah, go ahead.
So what if the arrangement was developed by the AI?
I think that's a situation where the Copyright Act says that it has to be, the author must be a human. And if the arrangement was done by the AI, the Copyright Office would likely reject the copyright application and would refuse that registration. So the important thing about kind of the ownership and authorship on AI has to do with where can you put in some human authorship so that you can, as a work as a whole, enforce that and stop somebody else from being able to use what you created. That's the copyright authorship. Second part to that is then use rights. Who can use the content? And a lot of that goes to the licenses that are associated with the AI systems that you're using. We're really talking about generative AI here on the output of either text, of graphics, pictures, video now, and audio. And really it's important to take a look at the terms of use associated with those. I've got a couple slides here, but before I get to those slides, I want to talk about inspiration first. And Ben, maybe you can touch base on inspiration and how, if we use AI for inspiration, like Sean was talking about, what step does it become yours versus the AI's? Or do you have to completely get rid of the AI generation that you've got? What I've got here on the screen is essentially it's an AI output. And my prompt was prepare a CAD stretch of an SUV vehicle that is inspired by the edge of a Lamborghini, the headlights of a Jeep, the tail of a 1965 Chevy, and the windows of a futuristic automobile. And just as a heads up, there are protections, IP protections on the shape of a Lamborghini and the headlamps of a Jeep. So that in context, I use that on purpose. Go ahead, Ben.
Yeah, so I feel like inspiration is perhaps the safest type of AI usage. And of course, the context that we're talking about here is when can you have ownership of the creation so that you could then enforce those rights and stop others from doing it. And I use inspiration. Inspiration is probably my number one use of AI right now. Is I'll just put in something into ChatGPT. I'll ask it to kind of tell me what the current state of the technology is, or I'll use it more like an encyclopedia, or like an encyclopedia or a dictionary, just to kind of consolidate information for me and give me a summary so that I can get up to speed more quickly. Definitely, when we start getting into this example, it starts to get much more gray, though, because if ultimately, you are just copying if you take this and just use it, well, that's not inspiration, right? So the question is really, how much is it inspiring you and how much is it actually creating it? And it gets to be a gray area because you have to really parse that out.
I want to talk about maybe two different usage models here and the way the Copyright Office is sort of dealing with it. The one being generate an image and then use that image as a starting point to do something sort of creative. And what we're talking about here is sort of that amount or modicum of addition that allows copyright to attach to that thing. And I want to contrast that or think about it relative to the extent of specificity provided to a model to the extent that that model is sufficiently, like that the input is sufficiently predictive of the output such that you're able to use the model more as a tool as opposed to a source of creativity. I personally think that as a model becomes more used as a tool as opposed to a source of creativity, there's greater argument that the human involved in that process is more driving the creativity in that process. And in my personal opinion, which is not the opinion of the Copyright Office, copyright should attach in those instances. But right now, that isn't the way it works, right? Like
Right.
the way it works now is you have to take the output of the AI and change that for copyright rights to attach.
I'm going to give a visual presentation on this one. 1 second. All right. So this was in here ahead of time, and I saw this, and it was a perfect opportunity to talk about exactly what Andy just said. So let's say that I'm the photographer of this black and white picture, okay? And I use Adobe Photoshop, and I go in and I color the red of the photograph, of the phone booth. If I use Adobe Photoshop without AI, I don't have to tell the Copyright Office that I used AI right now. And am I going to get a copyright on the entire picture, including the red? Yes. I'm going to get rights to the photograph as well as the artistic expression that I included on there. If, on the other hand, I tell the Copyright Office that I used AI to create the red, and for example, the new tools on, for example, Dolly, where I can go over and I can shade it, and I can say, color this red, I may not get the copyright protection on that red, even though I had the exact same expression on using two different tools. And that's what Andy's talking about when we're talking about tools and where the copyright laws, the regulations, aren't necessarily caught up with where the artists actually are.
Well, and with an example like that, if you're utilizing somebody else's photograph and changing it, at what point does it become your creation? Is there a certain percentage that it has to change in order for it to become a new creation versus you utilizing their creation?
Now you're probably getting into a little bit of either derivative works or joint authorship. And let's talk about both real quickly. So joint authorship is when you and I set out to create something and we know we're going out there to do this together. Okay? When you create a joint work, you have the right to go out and sell it. I have the right to go out and sell it, but we have to account for each other. So part of my sales have to go to you, part of your sales have to come to me. So there's a little bit that goes into a joint work. In other words, we have to basically intend to go into a joint work. And you can get that by circumstantial evidence. On the other hand, you're talking about perhaps you take someone else's work that's out there and you just make modifications to it. And if you do that and you're taking that other person's work, there's the underlying work that has copyright rights in it. And you potentially are creating a derivative, which is a right that the underlying author has that you don't have a right to. So to the extent that you are not transforming the work into something else, the underlying author has the rights. Now, you ask the question, at what point does it transform to something else? And there are some arguments. Sometimes it's a fair use argument. Sometimes it is there's so little left that you can't actually visually see that it's there, that would transform into the ownership of the second person. But most of the time, if you're going to still have the underlying work there, the underlying author is going to have rights against you as the author who's making the modifications.
So in this example, would you consider that a derivative work if the photo had been taken by someone else and then a subsequent person just colored that?
On this one, it would be, yeah. Now, coloring red may not be sufficient expression to actually get a copyright registration on that alone. But for example, if I took a backdrop of a city and then I colored in artistic expression in the front of it, I would potentially have copyright expression and rights on that front of the landscape that I put in, but I couldn't necessarily sell it because then I'd be infringing on the other person's right. So it's a right that I would have, but I couldn't do anything with that right because I would be infringing on someone else's.
Yeah, it's a good example. A perfect one that I just recently created a portrait of a friend of mine who happens to be a model, and I talked to the photographer who took this specific pose, but I wanted to transform that image and put like some graffiti background and different things like that into it. And so instead of just taking the image and just doing it and hoping they won't care, I reached out to both of them to see if they would be okay with it. And then for any sales from the print edition and stuff like that, they get a percentage of it, because I know she has a right as the model, he has a right as the photographer, and it's something that I want to do things by the right, and so it's something that I got that permission ahead of time. A lot of people don't, and so it's just one of those things that, especially in the Web3 side of things, to where you're seeing like a collection, and then all of a sudden they'll just flip the image and create a new collection and claim it's a new collection, even though we can tell it's just the same exact thing, just flipped.
Yep.
And so there's so much of that kind of usage in different aspects of Web3 and the right click and save thing. It's like, why would you pay $100,000 for this when you can just right click, save it, and adjust it and claim it's your own? And so that's a good example of how utilizing other people's artwork and changing it and what needs to happen in order for you to be able to use that. So.
Yeah. You mentioned getting licenses, essentially getting the rights from somebody. I want to skip all the way to the end of the presentation that I had up here because I have something on that exact thing. So I was using InVideo, which is an AI video creation program. And one of the things that they have on there, I watched a tutorial video, and the person who was doing the video was using and creating a video. And then, as you can see on here, maybe you can see the watermark where it's iStock. And when I first looked at that, I'm saying, well, if your iStock has its own license rights, you have to have a license to use an iStock image or video. And when I first saw this, I thought, well, this guy's creating using an iStock image, and then he's just using AI to take off the watermark. Well, not really. What happened was InVideo has a deal with iStock. And if you use the iStock images, then InVideo pays a license fee to iStock, and you have to pay more money in order to create that video using the iStock images. It's exactly the same thing you're talking about, of getting the rights associated with the underlying images to create your new video. The other thing is, this person said, it's fair use, and put it in quotes. No, it's not. There's actually you are an infringer unless you're not. So if you use someone else's rights, a lot of people just try to use, well, it's fair use. There is a very rigorous test you have to go through in order to make it a fair use. And let me tell you, when you use it for commercial rights, in other words, you're using it in connection with a business, most likely it is not considered fair use. Let's do this one. This is the OpenAI. Since we're talking about all these legal things right now, we'll keep talking about terms. So think about what rights you have in connection with a system like ChatGPT or DALL-E. The terms basically have a couple key provisions. One, the input, what you put into the prompt. Under those terms, generally, they say that the user, the person who's doing the prompting, owns those prompts. However, it's very important that you understand that the AI system has a license to whatever you put in at that point. Why would that be important? Well, let's talk about, let's say you're doing an invention. You have an invention, and you want to brainstorm in terms of what are some ideas that I would want to have, and you put in trade secret information that the public doesn't have. Do you now have exclusive rights to that? Not necessarily, because this license says you don't. And I want to talk to you, Ben. I'm going to key you up for this in terms of what potential patent rights you lose. But then I want to just touch base on the output first. So on the output, OpenAI, for example, says that the person who did the prompt has as much rights as they can. But like we've talked about, if it's all AI, it's not something that you're going to have exclusive rights to get a copyright registration, for example. You may have the right to use it, but you want to have the full right to get authorship and copyright registration. But content, which is both the input and output that you have, again, the AI organization or company, 9 times out of 10, or if not more, will have license rights to whatever you created and license rights to whatever you put in. That's why a lot of companies are coming up with and creating their own proprietary AI systems that don't have these license restrictions on them. Turn it over to you, Ben.
We've mostly been talking about copyright rights, and this topic is getting a little bit more into what Andy and I focus on, which is patents. And patents are a right to protect some kind of a technology or a process, right? So instead of artwork, it's like a tool or something like that. One of the key aspects of a patent is that you have to be the first one to have done something, basically in the world, which is a really amazing standard when you think about it. And as you know, many inventors are very secretive about their inventions. They don't go around telling anyone about it until they talk to Ben, to me or Andy, and make sure that they've got the protection, right? And the reason for that is because you can't disclose, in general terms, you can't disclose your invention to the public until you've filed your patent application, or at least that's the safest way to go. And so when we're dealing with AI tools, it is very dangerous and risky for someone to be taking that confidential information that they've developed and plugging it into this public tool that now can learn that information and can use that information. Now, whether that just giving it to it itself qualifies as like a public disclosure, that's one of the key phrases. I don't know. I don't think that's been decided yet, whether that itself would destroy your ability to get a patent on it. But if that tool then goes and starts telling people about it, well, certainly then at some point that is going to become public knowledge, and it's going to be something that you now can't get a patent on. So using a tool for that reason is very risky. Do you have anything else on this topic, Amy?
I think that probably covers the main point. I would say that generally speaking, we've talked about patents sort of at a high level. There's a couple different flavors. There's the sort of utility patent, the like interesting process. Maybe you've got an interesting process of like generating a bunch of artwork in bulk or whatever it is, and like no one else has ever done it before. That's perhaps protectable. There's also the other side of things, which is called the design patent, which is really directed to sort of ornamental appearance. You'll see this in consumer products a lot. So the kinds of things that you'll find on the shelf that have some fanciful appearance that were driven by a designer of some type, not driven by the functionality of the device. A lot of that is the images that Will had up of the vehicle. To what extent are those protectable? This goes back to both the concept that Will was talking about. You have rights in the item, given that it was inspired by other things, and the comments that Ben was talking about. Well, now that came out of this AI system, to what extent do I even have an ability to get protection on that, given that number one, I may not have created it, I might not be the inventor, and number two, it's already public. There's an obligation I have to tell the US Patent Office about everything that is public knowledge before I filed my patent application. How do I tell the patent office that this thing came out of an AI system and how my thing that's on the shelf is slightly different from what came out of that system? There's a lot of complexity there, so we typically tell folks who are trying to do those kinds of things, give them some guidelines on how to make some changes, how to capture what it is that they're doing to be able to adequately meet those obligations, to have something protectable and maximize their rights, so that when competitors see that thing on the shelf and see that it's selling well, how are you going to be able to keep others from doing it? Well, you're not going to be able to if it was entirely generated by AI. You've got no copyright rights. You probably don't have any patent rights because there's no human inventor. It's going to be much more difficult.
I've got an example up on the screen here, and it's a prompt. The prompt is, please develop a list of adhesives that work well between plastic and wood. For example, let's say that you're working on a patent application, you're an inventor, and you're creating this adhesive, or maybe you're creating something broader than this adhesive, and you just need this little part to work. and ChatGPT, for example, comes back and says epoxy resin, super glue, or Gorilla Glue, and has examples of the ingredients that are in there. Ben, if I'm looking at this example, what are the rights that I would potentially be giving up if I had ChatGPT do this versus using a search engine or maybe even looking it up in the library?
Right. So this goes back to kind of where we started the talk about like inspiration. If you're just using it for inspiration, I think that can be okay in some cases. But what you have to really think about is what. So in the terms of technology, you have to think about what's the new idea that's being added to what existed previously. And if you're connecting two things that previously existed, and all you're doing is you're finding the right adhesive that satisfies the particular needs of that application, and you're using the AI to figure that out, then you may not be able to protect that aspect, which is the only aspect that's protectable. So in that case, you may not be able to get rights from it. On the other hand, if this is just kind of an ancillary part of it, the widget that you're connecting to the table is unique, then this is just an add-on to that, and it's just kind of helping you through the process of developing that, and that's fine. So that's kind of, it really goes down to what is the human doing and what is the AI doing, and if the point of novelty is the term we use, the new aspect of your technology is the AI developing that, then you may not be able to protect that.
Go ahead.
So I can like take that down a level in detail here. So for folks who've ever seen a patent has claims in it. The claims are essentially what you say you own. If you say you own the connection between one thing and another via an adhesive, and that's what you came up with, that's great. You own that. If the specific adhesive was something that you came up with, that's great. You own that too. So that claim is fine. If it was already known to connect the two things via an adhesive, you need something more for it to be protectable. That something more has to be the new piece that Ben was talking about. And if it's not the one that you came up with, it's some new adhesive that was developed by an AI system that suggested something, and that is what ultimately becomes protectable. That becomes much more difficult because then it was the AI that was providing that, call it inventive activity, that was the difference between what was old and what was new. Now, patents have a lot of claims in them, and so you could have a claim that's like, connect the two things with an adhesive, and then the specific adhesive that was generated by the AI. And there's some fuzziness right now at the US Patent Office with respect to how to deal with that. But typically speaking, as long as there's a human inventor involved in the process, and specifically involved in the broadest concept of the invention, it's probably going to be fine.
So in this case, it was the human that prompted the AI about the use of adhesive to connect these two. So it's clear that the human already knew that idea. So they should be able to get that claim. But the AI contributed the specific adhesive that was the secret sauce. And in that case, they may not be able to get the claim.
It's kind of a far side example. What do we have on the screen? The prompt is, please create a form. And I always use the word please. I find that it works better. Please create a formula for an adhesive that would be good at adhering wood and plastic. Then the AI tool came out and it listed a bunch of different adhesives associated with that. And it did a follow-up. Prepare a patent claim regarding the invention of plastic and wood adhesive. And then the AI system created a patent claim that related to what I had talked about before. So in this example, I had the AI system do pretty much the entire thing. I did not add any creativity to this other than say, what is a wood adhesive or a wood and plastic adhesive?
You basically just identified the problem and then had the AI answer and come up with a solution to the problem.
Right. And what you're saying, both of you, is that for this one, I wouldn't get patent protection?
I would say it would be a struggle.
Okay. What would I do to get protection? How would I do it differently?
That's really dependent on what exists, because if the concept of connecting the two things via an adhesive is not new, and it is only in the potentiality of the specific material you're using that you'll find the newness. I think you'd have to at least propose some possibilities at the outset as human input. Whether they are ultimately the ideal solution is sort of beside the point, but they should be their own sort of unique solution set, such that hopefully the genus of solutions that includes your sort of suboptimal ideas and whatever you got out of the AI, you're able to define that in general terms to be able to get broader coverage on that subset of types of things that would work.
Who thought that they would be listening to a panel about adhesives on a Saturday morning?
Rivet.
Using it as an example. I want to take a quick pause and see if there are any questions from anyone who is in the room. In the back.
The biggest thing that I've noticed that has been the challenging side of it is in Web3 for instance, I built out the whole RTMP streaming for Unity, Unreal, and WebGL, and we had to have the specific specifications of the different applications that we were building it for it to be approved. And with that, we've noticed that we've even had patents denied because there was a relevance to AI that was not even anything remotely similar to what we have. Is that something that with a patent system is going to be continuous, that if anybody does a similar type of search or does it on an AI, that a patent would, on something that was actually hard-coded and developed by us, become situational for patents in the future?
Yeah, so there's a couple of challenges associated with software generally and AI specifically that I think are likely to continue to exist. There are a few existing requirements around patentability, one being what's called subject matter eligibility, and another being just it's got to be new and different enough. The subject matter eligibility piece basically says it's got to be tangibly beneficial, I think is probably the best way to describe it. And by tangibly beneficial, I mean not economically beneficial. And so what that ultimately has resulted in is a set of cases that have gone all the way up through the US Supreme Court and then percolated back down as guidelines into the US Patent Office that's requiring some strict language in patent claims to get them approved that is maybe narrower than what the law intended right now, and that's continuing to evolve. The Patent Office has issued some guidelines just about a month ago on AI inventions specifically and how they're analyzing AI inventions. Long story short, I think it's going to be difficult. I think it's going to stay being difficult. I think some of the challenges are the Patent Office wants you to tie your invention down to particular machines and to particular use cases, and that's very difficult in a distributed environment, in a compute environment that's, very flexible. And the ways in which we're able to sort of overcome those challenges are really at the points where the invention becomes fixed, right? So at a user experience level, at a particular endpoint where you've got some requirements, you really have to understand that underlying technology to identify those points and be able to claim those. It may not be claiming that end-to-end solution or the specifics of the entire protocol. It may be the specific pieces that are unique, because those, if someone else isn't able to implement that, their whole competitive solution falls apart, right? And so that's the way I would probably say you're going to wind up having to look at this. And is it going away tomorrow? No. Does that answer the?
Yeah, so give an example. I own the patents for gambling in Web3 which in terms was loosely put in for gambling in Web3 for Unity, Unreal, and WebGL. Then when it broke down to the actual how is it beneficial for the system and what kind of code we were including, we ended up putting in all the design functionality of the provably fair, which is what is required for a casino to be able to go up, where we built out that whole entire provably fair platform and secured that. That was what was the defining factor for us to be able to secure the patent for gambling in Web3 through provably fair. How would somebody in my situation who sees 500 other online casinos pop up in Web3 and they're using a form of provably fair which utilizes portions of my patent, would we go about being able to prevent that or stop them?
Yeah, without being so deep in the details there, I think that question probably touches on things like detectability, probably touches on the extent to which your implementation is required of sort of the broadest concept of provably fair and what that implementation is. And so it is possible, without knowing the details, that to define the specific technological advantage, you had to include some specific details from that body piece of your patent application into the claims. And by doing so, you wind up taking an invention, I was going to set this out, that was this, and it became kind of that.
And then it actually became
kind of that. And now it's not even that it's that. That might even be required. It's just hard to tell if someone's doing that, or they may be doing something really similar, and now you've given this up. So there are some strategies involved in this to start here, and then you get sort of a penumbra of rights around it that are a little softer. But if you start broad and you work your way down, you've sort of said, I've given up everything on my way down to this, so I don't get that additional penumbra of rights. So there are some strategies around how you do that, but the problem's not going to go away. It's still there.
One of the challenges that we have right now is that it is a changing area of the law, and the Patent Office is trying to respond to this by giving some guidelines, but the guidelines always end up being very general, and generic, and not necessarily that clear when you look at a specific situation like yours. And so even within different examiners at the Patent Office who are reviewing your patent application, you can get different results, right? And so some examiners might find something to be easily patentable, whereas the same claim at another examiner would be rejected as being not statutory subject matter. I've got a great example of that, which is really funny. I should give it to you for your slides for this presentation in the future. The invention was completely rejected by an examiner. Every single claim was rejected except for one. And so I went to that claim. I'm like, great, we've got one claim that's allowed. It said, wherein it's performed by machine learning. that was it. Just the fact that it was performed by machine learning made this patentable. And the vast majority of examiners would not have that same view. So it's pretty funny how there is some differences in the opinions by the examiners.
Yeah, the other thing I'll add to that, and to your experience, and if you've got a lot of patents in this space, I'm sure you've had this experience, is that the grant or not of a patent is not the definition of whether or not you have a legitimate invention. Patents are just sort of like snapshots in time of what you and the examiner of that individual patent can agree to. And the invention gets tested in a series of tests over time. Some of those are arguments with the examiner, and those get captured at waypoints by a grant of a patent. But one patent can become 2, can become 5, can become any number, and each of those may have different scope. And as you further develop that portfolio, that builds essentially an arrangement in which, yeah, the one is narrow, but if you've got enough sort of narrow pieces, you've got enough hammers to play whack-a-mole with.
Are there other questions?
Thank you.
Okay.
Okay. Hey, thanks, guys. I have one like intro to AI question and then one that's like kind of high level. And the intro to AI one is real quick. It's like I saw a video one recently of Elon Musk showing, oh, here's Grok's AI servers, and they're just going to town, and they're just, whatever. I'm from the blockchain world with Minnesota Blockchain Initiative, so I get the idea of Bitcoin mining and what those servers are doing. What are those computers doing to create an AI or establish the AI for Grok? I don't know what those servers are even doing. So I just want to understand that first off. And then secondly, the second question is one of the most promising things that I'm excited about with AI is the idea that it can solve problems that we don't, that we can't, or come up with inventions that we haven't yet figured out. Now, is all of that going to be unpatentable? Or how are companies going to try to profit from that so it's commercialized if it's AI that's solving these problems, coming up with these inventions, curing diseases, et cetera? Thanks.
So just, Andy, you can answer the tech question and then follow up on this. But I think one thing to just comment on is that the law in this area is ever changing, and the regulations associated with it are ever changing. So what it is right now is one snapshot in time, like Andy talked about, and how we interpret it and how we go forward with it is going to change. And it's just not possible in my mind that big companies, small companies, and individual inventors are simply going to give their works over to everyone else. There will be ways in which their inventions can be protected. That's what I'm going to say going forward. Whether it goes out that way, we'll see, but I think it will.
Yeah, to just piggyback on Will's, like right now maybe difficult to get patent protection if it's just solely an AI thing. That isn't the end of the story, right? Like companies will look at trade secret protection, they'll look at evolution of the law. There are a number of ways that they may get first mover advantages, for example, that the fact or not of protection is not going to be the holdup from companies utilizing AI. It's going to be the kind of thing that is going to trail, right? There's going to be lobbying efforts to adjust some of these things. So I would expect further development to happen on the actual ownership piece to match sort of commercial expectations. On the what is going on piece, it's every model's a little different in terms of the way that they work, but I would characterize it in two buckets. One, the creation of the model itself, which I would think of as an empty structure. And there are a large number of empty structures that can store a memory of as much of what is out there as possible. So the OpenAI chat GPTs of the world, I would think of as a big empty structure that you're waiting to impart knowledge on. And that's the first stage. That doesn't take a whole lot of compute power. The thing that takes a whole lot of compute power, I mean, it's not even the generation, it's the training piece. So the training piece that everyone's like talking about, or when OpenAI comes out with a new model every 6 months, it's because they've spent so much time training the thing on so many GPUs that they don't, they're running up the electricity bill of a small city probably. But it's taking, if you think about what training is you are defining the propensity for the AI to generate an output based on an input. So you're providing a set of inputs and a set of past observations, outputs, to say this is what would come out if you gave it this input. So if I ask Will the same question 10 days in a row, he may give me variants of an answer. Things are going okay. Things are all right. Any of those things, such that on day 11, if I ask him the same question, I'll be able to predict what he's going to tell me in response. That's what the AI is doing. I think about it like a Price is Right Plinko board. You're just dropping in the game pieces on the top, and the training moves the pegs to define the propensity to which the direction your Plinko chip is going to land in some place on the bottom. And so if you've done this a million times and you can predict that my Plinko chip, when entered in this spot in the top, it's going to wind up in this spot in the bottom. That's truly what AI is it's just generating propensities and to be able to do future prediction. Now, that gets crazy complex because if you think about that relative to like a diffusion model, like that's more than a Plinko chip, right? Like that's significantly more complex. And that complexity is just driven by pieces of images being used as training data, pieces of images being used as output, and the ability to sort of fuse all of those things together in a logical way.
Right. Any other questions? Yep.
Let's say hypothetically that there was an event being held and one of the people involved with the original organization of the event was no longer involved and had been asked by the event organizers to not be, but that person or that group continued to post pictures and logos and relationship sponsors about the event despite being asked to take it down. Would there be any recourse for that type of thing where it's essentially presenting themselves as a competing event that isn't the event and is using all of the artists and sponsors on their literature to do so? And is there any recourse for that, or is that something that this topic panel might be able to answer?
Well, you're essentially using the same kind of intellectual property that we've been talking about here. So let's set aside patents and design patents because that's likely not going to be an issue. But we are talking about potentially copyright issues. That's a form of expression. So if you think about artwork or any of the text that has been created, if it is owned by the original owner and not by the person who kind of branched off, then any use of that artwork expression by the other person is unauthorized and potentially a violation of that copyright. There's also trademark that we really haven't touched on a lot here today, as well as unfair competition. Those are federal claims based on trademark rights. Under trademark infringement itself, you need to have a trademark registration, but you can also have common law trademark infringement, so you don't have a registration on that. And unfair competition is then when there is a likelihood of confusion that someone believes that what the second person is doing is really what the first person or they're affiliated, connected, sponsored, or endorsed by. So there are federal laws that protect against that type of thing, as well as there are state laws, particularly here, we're in Minnesota right now. There's deceptive trade practices, and there are laws against being able to do that. So it would be a circumstance by circumstance situation. You'd have to look at all the facts. But if the hypothetical that you gave was that there was content that was being taken from the original organization owned those rights, and then the second person who branched off used those rights without permission, there would be laws to protect against that use.
And just to clarify, those owning the promotional material, for example, if the promotional material contained the logos of all the sponsors involved, would that actually be their quote unquote artwork for that event? But if the sponsors were not part of that event,
yeah,
that's copyright then?
Well, actually, you're going beyond that. It would include all the things that I just talked about, but then the sponsors would potentially have rights to go against the second party as well, because they did not give their right to use their logo in connection with this third-party event, and may not want to be sponsored by that third-party event and not want to have the affiliation, sponsorship, connection, or endorsement by that other entity.
For sure. And that goes for in-kind sponsors and paid sponsors?
It would be anyone where a consumer, anyone who's attending the conference or would see it in the public, would be confused that there would be a connection.
Perfect. Thank you.
Yeah.
I have a quick.
I'll make this pretty quick. It was based off of a question that was just asked in terms of future patent availability. So let's say I'm sitting here for a few months and I am putting in prompts to solve a problem. I'll use adhesive as the example here. I create an adhesive through AI. Finally, after months, it gives me a crazy ingredient that I put into this, and it makes it amazing, stronger than steel. could I essentially, with today's situation, could I essentially could I unleash that onto the world and stop people from making future patent requests on that as essentially a derivative of what I pulled off of the AI?
Yes, your public disclosure of that specific material acts as a bar to patentability, not just for you, but for others.
I have a quick question. There's a lot of new creators that are coming into this space and doing artwork and music and different things like that. And one of my friends, came up to me and asked, where is the best place to go and get the information needed to try and protect the work that you're creating? If you have somebody new that's coming in, is there a single resource that you would recommend to research and learn about what they need to do to protect the rights of what they're creating? Or where would you look? Where would that be for the average consumer to know what to copyright, trademark, patent, etc.?
Well, I would say that's what we're for. But if you're talking about wanting to interpret what the law means and get an interpretation of it and how it will impact your business and how it will impact you as an individual. Though I think that you have to be very careful in going on to, for example, like a YouTube or looking at videos, because the contents that's going to be there may be swayed, may not actually be factually accurate. I think there's books that talk about kind of the basics of intellectual property. That's probably the best and safest spot to actually learn if you want to not go hire an attorney who specializes in these areas, because they've taken the time to write it and author it, get it published. I get that you can write a book on AI before lunch. I'm not talking about those books. I'm talking about books by reputable attorneys who know about the intellectual property aspect you're talking about. The other thing is to stay up to speed on articles that are written by attorneys who are practicing this space, because they will give you some guidance in connection with where the law is going, where you have to kind of be careful for pitfalls, be careful for those potholes that you don't want to go over, and just think. I think that's the number one thing is just think before you just do, and don't just follow everybody else because they're doing it. That's a big problem with the internet. People, when it first came out, said, well, I can take the images off of the internet because they're on the internet. They're free to use. No, they're not. They're only the images that are in the public domain are free to use. Otherwise, the images are protected by the authors and the owners of those images. So be careful. I guess that's the biggest point.
Wonderful. Yeah, it's always something as a creator and an artist, like you're constantly creating new content and things like that. And do you copyright every single painting you do? Do you copyright every single, mural or street art or different thing, or music or song or whatever? And so it's just a matter of like getting started in that for like the artists that are just getting going, and with everything on Web3 and just the different elements, because it's completely different than when I started creating, street art 19 years ago. And so there's so many different aspects of that. And so it's just good to know and have those resources for people to be able to find out if they should be doing something and whatnot. So thank you.
Awesome. All right. We'll stick around if there's any other questions, but otherwise, thanks for attending.